The following is a pre-recorded show. Welcome to Winning in Retirement with your host, Brian Akers, certified financial planner professional and founder of Akers Financial Group. Now, helping you win in your retirement, here's Brian Akers.
Welcome to Winning in Retirement. I'm Brian Akers, president and founder of Akers Financial Group. I'm a certified financial planner practitioner. I've been working and doing financial services since 1987. Now, today's show is a very special show, and what I've done is invited one of my friends for a long time. He's an attorney, so forgive him for that, but we want to welcome Kevin Brest to our show. How you doing, Kevin?
Good, Brian, and I'll take my punches. I'm sure I'm going to get a few more.
He's been working and serving longer than me by a couple of years. That's fair to say, right,
That's
Kevin?
Another punch.
Yeah. That's the last punch I had, man. That's it. All right, so today we're talking about what is your legacy? You know, you work hard and you build and you invest your money, you save your money, you grow, you save. You have all these things that you've been working hard for. Now, what do you do? And the reason we want to invite a legal expert, Kevin, in is to talk about ideas. And I have a lot of questions for Kevin's with different clients I've been talking with in the last couple of months about the good things, the bad things, the concerns. But what is your legacy is going to be the topic of our basic show. But I'm going to be asking Kevin questions that a lot of my clients have to ask him. So, Kevin, are you ready?
I'm ready. Let's go.
All right. Let's just start with the basics. What law firm is that you and Ashley have? What's your name of your law firm?
Well, thanks, Brian. We just set out a shingle in Bel Air covering Central Maryland, but it's Brest Route Law Firm. So that's Ashley and I, and we're going great guns.
Ashley was on a previous show earlier this year. You can see those at akersfinancialgroup.com under the radio tab and check that out. Now, Kevin, you've done this before, estate planning. Has that been a specialty of yours for your career?
Brian, I was focused on estate planning when I was in law school, believe it or not. So
and that was University of Baltimore?
University of Baltimore. I did a master's in tax while I was there.
Just for fun?
Just for fun. And when they said, here's the master's in tax class, I was the only one who stood up.
No way. No, I don't mean to be nerding, but I think I'd like to take that class someday. I've never done that. I've done a lot of other courses, but not that one.
Well, I do tutoring too, so if you're busy on Sundays, we can get
That's your spare time you do that? I know you were a professor for a while.
Yeah, no, I'm kidding about the tutoring. But right, I did teach for 15 years at the law school.
Oh, that's nice. All right, so today on the radio show, Winning in Retirement, we're going to talk about what is your legacy and talk about some basic things when it comes to concerns that clients have. Some of them are basic and some of them are more advanced. That's why we have Kevin in here. So what we're going to talk about is my first question, Kevin, is why do people wait so long to get their legal documents in place?
I have three reasons.
All right.
One is denial. People aren't going to die, at least anytime soon. So in their minds, I'll get to it, and it's bucket list number 9.5,
All right, so in the future, I'll worry about that, but they currently live in denial.
That's right. And it's not until someone around them often that has a problem. So a friend passes away,
right.
A diagnosis comes down, even for that person themselves, and then suddenly they're in a hurry.
And that happens in financial planning, too. People think about retirement, but they don't do anything about it until all of a sudden there's a reality check where, there is a timeline. I need this. Now, what you're saying about the denial, I think, is very, very important. I work with a lot of policemen, and it's almost like if you admit that weakness that you might pass away, it might change their mindset so that they don't even have wills, even if they're provided for free through their police force. And so I found that with military gets it required, but the police force has been one that I really try to work hard with to make sure they properly plan for the worst and then live the rest of their life without worrying about any of that because it's already in place.
I spoke with the Maryland State Police, a big group in Pikesville 2 days ago.
Okay.
And normally when I get up and talk about power of attorney, I'm talking about, well, you lose mental capacity, you get dementia. But I'm looking at all these state troopers and I'm saying, you get grazed by a bullet, your line of duty could cause you to have a mental incapacitation. So, you're not immortal. And so we need to look at it that way.
All right. So that's number one, denial. What's the other couple of reasons that people do not do their wills? They put it off.
Fear of the unknown. They don't know what the process is.
Okay.
They've not been through it. They're afraid. It's difficult, it's painful, and it's expensive. And in fact, none of those have to be true if they're dealing, with the right people.
All right, so walk through a process. Someone is listening to the show today. They call in, and then now they're going to call you and set up that process. What is that process that you like to take people through?
I like to send them a 2-page agenda, Brian, so that they know what we're going to talk about and they can start thinking about it. We then go through their family, any issues with the family, any needs that are special, and then how to resolve and plan for those and to fix those. And so when people say, hey, can't I just do a will online? You're not going to get the interaction online. So that's the value added of having an attorney do estate planning.
You can apply it to the exact situation. That's really the key thing.
Right. There's a lot of listening an attorney has to do to understand what might fit their situation.
And in any case, when someone works with you, they know what they're going to pay for that first hour. They know what they're going to pay ahead of time. It's not going to be a surprise. It's not going to be a hello, every second is billed. You're going to give them you're going to tell them up front what's going on.
I liken it, Brian, to a gentleman going out and buying a suit. All right. When
Sure.
You go to stores, suits cost within a certain range, generally speaking, and I can predict what a cost is going to be up front and tell the person. Once in a while, you get a guy who wants a custom suit, and so we're going to bill him by the hour, and it's going to run a little bit more. But I would say that's 5% of my clientele.
Sure. So basically, when we're talking about reasons people put off getting their legal documents in place, we said denial, and then understanding the process and being fearful of understanding the process. What's the third one?
The third one is cost, which you kind of hit on.
Yeah.
People are afraid they're getting into thousands of dollars for estate planning. Now, gone are the days $100, $200.
Right.
But generally speaking, people are in the $1,000 to $2,000 range. Sounds like a lot of money, but that planning can sit in good shape for 5 to 10 years. So you amortize that out. It's not that expensive.
And it's actually cheaper than passing away without the documents being done or being incapacitated without the documents being done. Because it would be a lot more costly to have to do it immediately after the fact.
The most vivid demonstration of what you just said is the power of attorney that never got done.
Sure.
And now the wife or the child is trying to deal with dad's assets. They're in circuit court having a guardian appointed. They need a lawyer for dad. They need a lawyer for themselves. Some child wants a challenge. They need a lawyer. You could be $5,000, $10,000.
Yeah, just at the beginning, just to say hello.
Right.
That kind of situation. All right. So what we're talking about is what is your legacy? And we're starting with the basics about why people wait and they don't do this right away. Now, in my financial planning practice, we've found when people come in, more than half come in with no documents at all. No matter what age, they've never done these documents. So we recommend that you go get your documents done immediately, no matter what age you are. Now, as we're talking about documents, I want to cover things such as wills and maybe wills-based planning versus trust-based planning. If you could give us an overview of those choices or what would cause people to choose a wills or trust, if you could give us that in like a short 30 seconds.
Okay.
I'm sorry.
29, 28.
Are you done yet? Okay. No.
So my approach, Brian, is keep it as simple as I can to begin with. So I'm going to assume in a meeting we're going to do a basic will. But as the conversation goes on, I might hear something that cues me to say, that can be resolved with a trust. So if somebody says, I want to leave money to my daughter and she'll take care of my son who has a disability, I'm going to say, well, if you just give her the money, what happens if she dies? What happens if she's in it? Maybe you want a trust for your son. Mm-hmm. So then they say, what's a trust? How's a trust work? And I don't have more seconds to...
I was joking about the 30 seconds. We got a couple more minutes. So you can go with basic trust for me.
Basic trust.
Yeah.
So, and it's all within the family. I think people fear trust because they think there's some ivory tower trustee guy who's out there managing the money. No, it's done in the living room, basically.
Sure. So the idea of wills means that the person uses that will for probate when after a person passes away. Could you explain the basics of what the word probate means?
Yeah, a good way to understand probate is to understand what's not probate. That's the easier approach for me.
Sure.
If husband and wife own something jointly and one dies, it's not probate. The ownership of the house goes right to the surviving spouse.
Sure.
If you name a beneficiary on life insurance, you name a beneficiary on your IRA, all the things you can name beneficiaries on don't go through probate. So by default, the third category is when you don't have either of the first two categories, you own a car, you die, who owns your car? Your estate owns your car, and the laws of probate dictate how to get that car out of the estate to the beneficiary.
Yeah, and then the government agency that helps guide that is the Register of Wills and located in each county?
Exactly, and they're an administrative arm to the Orphans Court, which really should be called, Brian, the probate court. But
sure.
Maryland has not spent the money to change all the stationery to probate court.
So every county, the city, each has their own court that's set up for this.
And Register of Wills.
And Register of Wills. All right. So what we've been talking about is what is your legacy? And we're covering the basics about the reasons or the people put it off. So you got to think about it. Those are the reasons we should not put it off. We don't need to be in denial about things in life. We need to handle the worst case scenarios, put things in writing, get it done, and then it's behind you. You can move on. I'd rather handle the big issues in life and then work on the best. What do you think about handling the worst case scenarios, Kevin?
Well, look, I've been doing this 35 years, and the challenges are the fun ones. But I mean, I don't want that to be at the sake of the client.
Yeah.
But I have some really good challenges where they have so much wealth, they need a lot of help to not have it completely shrunken by the tax system.
Absolutely. So what we're talking about is a legacy, and then we have attorney Kevin Bress here today from Bress Rout Legal, our law firm out of Bel Air. When we're talking about their show today, Winning in Retirement, we think part of winning in retirement is knowing that you have everything in place that you need to have a good financial plan, and that truly allows you to win and not worry about worst case scenarios. Now, Acres Financial, we're local. We're independent. We don't report to a company on Wall Street. We report to you. We do have offices in Lutherville and Forest Hill, clients all around the Mid-Atlantic region and clients all around the country. So it's so easy to begin winning in retirement. So go ahead and give us a call and schedule your meeting with one of our team of advisors. And by calling 833-WIN-RETIRE, that's 833-WIN-RETIRE. We'll give you a call on Monday to schedule your free in-person or Zoom meeting. Go to acresfinancialgroup.com or call us at 833-946-7384 to start planning for your retirement now. Retire to another state? Are you legally ready? We will talk about this when we return in a moment.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Welcome back to Winning in Retirement. I'm Brian Akers, certified financial planner practitioner from Akers Financial Group. Here with me today is attorney Kevin Bress, and I've known for many years. He's an expert attorney who's been practicing in the area of estate planning for more than 35 years. He and his partner, Ashley Rout, have a law firm, Bress Rout Law LLC in Bel Air. Kevin has been a great resource and very helpful for many of our clients and speaks at our annual events that we have for our clients, which is on our website at acresfinancialgroup.com. All right, Kevin, you ready to go for second quarter?
Let's go, Brian. This is fun.
I didn't wear you out in the first quarter. That's good. You're just getting started here. All right, so this quarter, I got this first question I got to hit you with, and that's this. Oh, where's my paper? There we go. Retire to another state. Are you legally ready? All right, so everyone's thinking, oh, I want to retire to another state. Sunny, warm, beach between my toes, all that type of dream thing. The reality is when someone does move from Maryland to another state and has legal documents in place, what should be their concerns? What should they do as they move to a different state if they become a resident of another state?
The nice thing about the country is we have something called the U.S. Constitution.
No way.
And I'm not talking about all this political stuff.
Sure.
And one of the clauses in the Constitution is that the states shall give full faith and credit to the laws of the other states.
Okay.
So how does that come into a will? You do a valid will in Maryland, you move to Florida, it's a valid will. Florida doesn't get to make you check it at the border.
Oh, you're not checked at the border with your passport and your will.
That's right. They don't shake you down. So Maryland wills are fine, Maryland powers of attorney, etc. But nonetheless, every state has some quirks as to language, statutes. So we say to our clients, get to Florida, settle in, enjoy yourselves, and invariably you want to update your planning every so many years anyway. Have a lawyer look at what you did in Maryland, and maybe it needs some tweaking.
Now, lawyers have to be licensed in each state they work in. Is that fair to say?
It is. It's. I am incompetent in 49 other states.
Okay, so you haven't passed the bar in 49 other states.
That's right.
Okay. Now, what happens is this: as a financial planner, I have clients in Maryland, and then they retire to another state, and it's easy for me to be licensed in 29 different states, like I am. Or I'm nationally licensed as an investment advisor, financial planner. It's sort of easy for me because they just want money, just pay a fee. But as a lawyer, you have to actually take tests, right, in certain states to be able to practice there?
Right. It's not a matter of, how good you are. It's even if I pass the bar in Florida up here, I have to keep up with the laws of Florida.
Sure.
And their nuances.
Absolutely.
And hey, the guy in the government, he doesn't like people doing it this way or that way. Well, I don't know that. So I'm not doing my clients a service trying to be a jack of all states.
Right. Absolutely. So what happens is this in planning is that when we have clients that are truly considering about retiring or doing the snowbird concept or owning properties in multiple states, there are legal issues to think about. So let me ask you the first question. Someone is getting ready to retire. They're getting ready to buy that first place in Florida, but they got a couple more years to work. They're going to be here in Maryland. Having property in both states, what kind of legal documents should they be considering?
Well, an interesting thing, Brian, with the law is that real estate has to be probated in the state where it's located.
Okay.
So heaven help somebody who has 4 different properties in 4 different states and dies, they're going to have 4 different lawyers doing probate.
Right, because they have to hire a lawyer in every state to represent the family, to do the person that passed away's estate and the paperwork. And then there's a cost for each one of those.
Potentially, unless they figure out how to do it themselves. Right.
Sure.
And so we have a way around that by having that. You talked of the previous segment about a trust. So property can be put in a trust and avoid that outcome.
Right. And that property in the trust, can that only be done when you buy, or can you do that after you purchase the house?
Either way is fine.
And you found that to be easy if there was a mortgage on it, or not easy with a mortgage?
The type of trust is so invisible, banks don't care about it. So it works fine. It's called a revocable living trust.
All right. So revocable living trust, one of the reasons to have one would be if you have property in multiple states.
Exactly.
That would be a fair thing to say. Okay.
Right.
Now, in estate planning, there's a package of legal documents. What does that comprise of? What are the different type of documents that if someone came to you, what kind of documents would you want to provide them with?
Yeah, there's 3 documents. Consider it a 3-legged stool.
Okay.
You don't want to sit on a 2-legged stool. You want to have the 3.
Okay.
Power of attorney, a medical directive, and that one's a little more to unpack, but
Sure.
A medical directive and a will. And we know we're going to die someday. So the will, that's a straight shot. The other 2 I call fire extinguishers.
Sure.
You may never need them. You may, as Louis Goldstein, comptroller of Maryland, once said, you may just wake up
Louis
dead.
P. Goldstein, right?
What's that?
Wasn't it Louis P.?
Louis P.
Yeah, I remember that commercial.
He said, I hope I just wake up dead sometime.
Yeah.
And then you don't need the powers of attorney.
Right. So the power of attorney and the, what do you call it, healthcare power of attorney?
Medical directive.
Medical directive. Okay, medical directive. Those, are they basically just Maryland? You have to get a new one if you move? Or do those transfer to a state easily or not?
So here we are again. Maryland has a whole concept called Medical Orders for Life-Sustaining Treatment, acronym MOLST.
That's your favorite word, isn't it?
MOLST.
MOLST. M-O-L-S-T?
You can't say it if you're chewing gum.
No.
MOLST. And Pennsylvania calls it POLST.
Really?
Physician's Order for Life-Sustaining Treatment. So when you do documents in Maryland, they're geared toward what is happening in Maryland.
Sure.
So that's why it's a great country.
Yeah. All right. Because I do have clients who retire, and we have to decide, are you going to be in Florida more than 6 months? Are you going to truly be a resident of that next state? clients go to Tennessee. Last week was South Carolina. And we're talking about how to become a resident and what makes you a resident. And once you're a resident, things to talk about tax-wise. And then we're talking about the legal side. And I was saying about you got to see an attorney in that area. Now in Florida, you have to get an attorney that's appointed for that local county. Because just like the weird thing in Florida is that insurance agents got to get appointed every county in Florida.
Oh my gosh!
Yeah, and the lawyers have the same thing. So I have a network of people that I call down in Florida for clients, but generally in each state you got to build this network over the years of working, and that network is where if you are doing like that trust you mentioned earlier, and someone already owns a place here in Maryland, they do their own trust. Now, to retitle their out-of-state property, you need to get in contact with a lawyer in that other state. Isn't that correct, to change the deed?
That's right. Deeds generally would be prepared and filed through an attorney in that state.
Yeah. And so what happens is this. We are talking about what is your legacy? What are you building? What are you growing? And one of the reasons that we want to have an attorney in to talk about this, we want you to be winning. We want decisions to be made so that this money you built and saved and grow will pass to your kids, your family, the way you want it passed. We want it to be simple. We want it to be as easy as possible. And that's what good legal documents do, right, Kevin?
Right. And a lot of people, have been fortunate and have amassed very nice net worth.
Right.
And I go a step further, Brian, than just talking about their legacy, but the legacy for their next generation.
Oh, yeah, grandchildren and great-grandchildren. Because we all know people love their grandchildren more than their kids, right?
Right. I've seen, a little bit of that. And so what I encourage people to think about is handing the money to their kids in what I call an armored truck that nobody else can get in except the kids. Sure. And that way, when your children might go through a divorce, they might get sued for something like a bad car accident, the money is in protected vehicle, and that's your trust. Mm-hmm. And a lot of people don't think that far ahead, but I think with the focus now on children and grandchildren, they will.
Yeah, so an armored truck is a vehicle that's really, really tight, and it's hard to get in and hard to get out. Now, is this type of vehicle an entity unto itself after you pass away?
It's an entity, but the child basically doesn't have to pay a whole lot of attention to it other than file a tax return for it every year.
Yeah, separate tax return for that kind of armored truck trust.
Yes. Maybe I'll copyright that. Yeah.
That sounds fun. It's more fun to say it that way. Because what happens is this. We know who we want to give money to. And then the idea is we need to create a way to get it. So if we're going down a path, we might as well drive an armored truck. I'm okay with that. It goes a little slower, but you're going to get there.
Right. And for children, you're doing estate planning that they wouldn't have thought of doing for themselves.
Yeah. So if you built wealth and build a legacy and you're going to hand it over to them, if you give it directly in their name and they can do whatever they want, it'd also be subject to whatever's going on in their life, from creditors to even possible divorce settlements, depending on how they handle that money once that money comes in.
Or they become disabled and their medical bills go through this roof.
Absolutely.
The truck is protected.
Right. All right. So you're listening to the show. You're thinking about what is your legacy. This topic this quarter has been about moving to another state. And then I mentioned about what if we have property in 2 different states. Now, the idea of moving to another state is a lot of people's goals. And what happens is they'll move. Typically, they'll move during, I call it the more golden part of the years, when things slow down and we want to move back closer to a lot of family. We actually come back to Maryland, and then we have to get things readdressed. And that can be good and bad, depending on really what shape you are when you come back. But the idea of these documents, I guess the basic thing what you said is that you don't have to be in a rush when you change states, but you should get it reviewed. And then when they come back to Maryland, the same thing should happen. They need to have it reviewed again.
Your point is good, Brian, because people do change their minds. And when I have somebody say, I want to put the Pennsylvania property in trust, I say, might you sell it at some point? Oh, yeah, actually, we're thinking of selling it. So we say, well, why don't you wait and let's revisit that in a year? So jumping the gun on these things can get people very frustrated. We take it slow.
Yeah. So the idea is this. You need to think about what is your legacy. Draw your family tree out. Draw the people that are there. When you work with an attorney and you prepare, the process is you write down basically who you want to receive your assets and when. That's a really good thing to do at any point in time, is to think about this process and to re-examine, is your estate actually going to flow? Now, at Acres Financial Group, we call this a financial fingerprint, where we talk about your exact situation. We talk about exactly what you want it to do. The idea of financial planning is take where you are now, we take the numbers, the income, the taxes, and the estate plan to make sure it flows the way you have designed. It's not about us, it's going to be about you. So go ahead and give us a call at Acres Financial Group by calling us 833-WIN-RETIRE and schedule an in-person or Zoom meeting with one of our team of advisors. That's 833-WIN-RETIRE, 833-946-7384, or visit our website at acresfinancialgroup.com. Scroll down to the bottom of our homepage and schedule a meeting right there. Call 833-WIN-RETIRE or go to our website, acresfinancialgroup.com. You might need to parent your parents. We'll talk about this in a moment.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Indeed. Welcome back to Winning in Retirement. I'm Brian Akers, Certified Financial Planner Practitioner, and I'm here today with Kevin Bress. He's an expert attorney, I like to say. An excellent attorney when it comes to estate planning. His law firm is Bress Rout and located in Bel Air. He's been a great resource for my clients for a lot of years, and so we welcome him to our radio show. Now, Kevin, I got to tease you a little bit about halftime and halftime of games. So during your college years, the University of Baltimore football team, what did you guys do at halftime?
Well, we had one of those vibrating boards in the library with the little football players.
Oh, you had the metal football?
That was our team.
I went to Virginia Tech, and so Virginia Tech, we had the Hokies, and we had good football, Bruce Smith, and a bunch of really good teams as Frank Beamer took off at those years. But not that good anymore, but it used to be great. The reason I like to talk about halftime is that we got to get ourselves pepped up for the second half. Are you ready to talk legal?
Oh, yeah. The adrenaline is running.
I can tell. I can't hold you back. Okay, we're talking about what is legacy. And then this quarter, I have a tough subject. And this subject is this. You might need to parent your parents. And the reason I bring this up is I have clients that are getting ready to retire. The kids are like leaving the back door, but then their parents might be moving in the front door. And there's these major decisions happening in their life where the parents are at a point where they might need some help. If you put yourself as the advisor for that retiring person in that situation with their parents that need some help, and they need to have the ability to help them. What are some concerns and things that people need to think about if that is their current situation?
Well, Brian, you bring up something that I've really enjoyed helping families with recently. And of course, there's legal documents. There's the power of attorney. There's the medical directive the parents should have to enable the child to help them. But there's the whole personal element that over the years, I've become bolder and more communicative about what I'll call the social work issues of how children should be interacting with their parents, how children should be interacting with their brother or their sister. There's some animosities that go on. There's some ability to get the parent to realize they can't do things for themselves.
Yeah.
And you don't think of a lawyer as helping you with that. But the upshot is if you don't handle it right, you're in court with a lawyer anyway. So why not get some advice on the front end?
Do you have a referee shirt for that?
And a whistle.
And a whistle. Wow.
Time out.
All right. So what happens is one of the kids come in and they say, I got some questions about my parents. And then I guess the hardest part I would have is, well, can you, as a lawyer, represent that kid and the parents, or do you have to bring other lawyers in? How does that work?
That's challenging. It's challenging because ideally I'm representing the parent who's coming in.
Sure.
My first question when the child comes in is, do you have power of attorney to act for your parent currently?
Or to even talk about it, right?
Right. Now, if the child says, I don't have power of attorney, but I want the advice for myself, how to deal with my parent, I'm okay with that.
Sure. All right, so let's talk about that first thing you pointed out, and that is that the person coming in is getting ready to retire, concerned about their parents. So what are some normal concerns you hear, and then what are some things that they need to think about doing?
One is that the parent is not taking care of business the way they should.
So there's a concern about taking care of themselves financially, physically, the house, or even with the doctors where they go to a doctor and they might not hear everything the doctor says and things just don't seem right.
Right. And we still haven't gotten to a point where you can be issued a butterfly net, throw it over your parent's head and drag them into where they should be.
Yeah.
So there's a lot of psychology that goes on here on how to work the parent.
Sure.
Anything from they'll listen to the doctor. Well, then we got to get the doctor talking to them. They'll listen to the lawyer. We got to get the lawyer talking to them. They'll listen to big brother, but not little brother. It's somewhat obvious, but it's overlooked.
What if the child that has concern is not the power of attorney and their older sister or brother is already the power of attorney? What rights does that child have, if any?
So we're trying to get the family together as a group.
Okay.
So if the younger child doesn't have rights, if they're coming to me and I start giving them ideas and planning issues, that may be the hook that gets everybody to the table.
Sure.
Mom's going to lose all her money in the nursing home. No, she doesn't have to. Why don't you tell them I can help save the money? And then we have a common conversation.
All right, so a common conversation. Could that be called a family meeting?
Exactly.
All right, and so a family meeting, they'd all come in. And how does that go? What is a family meeting like?
Sometimes the first meeting, Brian, is without the parent because there's a lot of heavy technical talk going on.
Sure.
And then once we sort of narrow the field of choices, bring the parent in and say, here's what we think is best. And the parent often just glares over at the child and says, is that a good idea? Should I do that?
Yeah.
And they're willing to.
Yeah, it always depends on the timing and like if the parent is still very viable mentally in talking with you, or if it's already too late for them to make decisions like that anymore. That's a tough place to be when it comes to a lawyer, right?
You've seen it probably in your financial planning business when you say to your client, and I think this is a good idea, and the client says, yeah, I'm going to think about that, which means you won't hear from them again.
Yeah.
So with the children there, it's like, Mom, we need to make a decision now. Let's go. Yeah. And that helps.
It does. I've had situations where I've had clients a long time, and all of a sudden things change a little bit, and that's when I usually call. Usually we have all the documents in place, so I know who to call. And they also, when you set up brokerage accounts now, and you're over 65, you have to put a trusted person, a trusted contact. So as a broker and an investment advisor representative, I actually have the person's name and number written down, who the person's given me permission to call if there's a concern.
It's such a common sense thing, and look how long it took for that to become a normal thing.
It's part of the forms now, but it used to be just part of our planning. We'd write it down in our document that we do for every meeting. But the idea is when you have to do that for a client is tough. One case I had a client that she was an auditor, very good at finance. And then 1 year she came in and could not balance her checkbook anymore. And so for me, I knew that something's really going on. So we had our talk. We didn't do anything. I just called the daughter after that, and I said, you need to talk to your mom. I'd like you to be at our future meetings so that I can understand if she understands what I'm doing. I want you to know, as her power of attorney, what it would be like. And so she ended up, the daughter came to all the meetings after that. It worked out very well to take care of her mother the last 8 to 10 years of Mom's life. But that was one of those meetings. We also had some tougher meetings where the father did not want help, even to a point where the daughter was trying to take the car away because of being dangerous. And that was a whole family argument. So I just wanted to bring up this, how, if you think you might have to parent a parent, what are some of the concerns and what are the very important documents that they need to have in place? So basically, if there is no documents in place, the medical power of attorney, what does that do for that kid who wants to take care of their parent?
Well, they're going to possibly have disagreements with somebody else, and they don't have the legal authority to override somebody else.
Sure.
So if it's in writing in the document, their word carries the day, as opposed to a default of it being all the children. And, the more children there are, Brian, the more likely a couple of them are going to disagree.
All right. So how does a doctor know you have such a document, and how does a doctor know that this is their wishes and this is the person to talk to? How does that work?
Well, it's hard to run through this whole thing with you right now, but there is a way to upload your advance directive so the doctors and the hospitals have access to it.
Sure.
Going forward.
Absolutely.
With a click of a button.
Right. So that's a very important process. That's one of the things we're going to cover at one of our training day events. So if you check out acresfinancialgroup.com and check out our training day, Kevin will be one of our speakers. So will Ashley Robb, to be able to talk legal documents that day in person. If you guys are welcome, you guys are all welcome to come to our training event. So that's something in a couple more months from now.
Excellent. Yeah, October, I think.
October 13th is what we're looking for. Yeah.
Good. I'm ready.
Yeah, good. All right. So this topic of when you need to parent your parents, let's talk about real estate. All right. So one thing is, what if that kid moves in with the parent in the parent's house? What are some options that people have when you move in with your parents at their house when it comes to issues that could concern even the property and for the ability for it to be protected from possible nursing homes in the future? There's lots of issues going on there.
Yeah, that, a lot of times, Brian, I try to steer people to self-help and do what they can for themselves. But when it comes to real estate, that's the province of an attorney, because there's
Absolutely.
Just too many legal issues and face it, real estate's one of your most valuable assets.
Yep.
And it's worth protecting, as you say. So there's some unique deed titling that we do to protect the child, because if the child gave up their home to move in with the parent, they don't want to be finding out the state of Maryland has a lien on that house because things weren't done correctly with mom's long-term care in a nursing home.
Yeah, so there's decisions I've heard made by people, and then I sort of come in after the fact. It's like, well, what did you do? One of the things I see is sometimes they'll add their kids onto the title as a joint on the title just because they felt that was the right thing. And I just try to explain tax reasons not to do that. There's just a lot of quick decisions that are done, which they don't involve attorneys when it comes to real estate. And it drives me crazy some days.
Yeah. And the joint titling is the knee-jerk reaction to, I got to put my kid's name on here so they'll get the house. What they don't know is there's a type of deed that accomplishes that without the risks, without the tax problems.
Right.
But it's not in the forefront because it's just something people don't come across. But lawyers, we do these life estate deeds all the time.
And this is a proper way to deed your home when you're trying to protect it from issues such as extreme expense for nursing care and long-term care. So you got to make sure you take advantage of these concepts, these ideas, and really think about how you want things to work when something happens. If you find yourself parenting a parent, you got to know what you need to know. And that's one of the reasons I want to bring that up this quarter was that. All right, that was very excellent there, Kevin. The Acres Financial Group. We at Acres Financial Group, we want you to win in your retirement years, because the best part of retirement is getting your time back, where you decide how to use it. Before retirement, your time is tied up with other commitments, mainly your job. A lot of that goes away when you retire. Your time is now consumed by things that you want to do. It's so easy to begin winning in retirement. Go ahead to our website at acresfinancialgroup.com. Scroll to the schedule meeting section and let us know you'd like to schedule your free consultation with one of our team of advisors. That's acresfinancialgroup.com, or call us at 833-WIN-RETIRE. That's 833-WIN-RETIRE. We will call you on Monday to schedule your free in-person or Zoom meeting. Go to acresfinancialgroup.com or call us at 833-946-7384 to start planning for your retirement now. Family, kids, and legacy. What do you need to know? We will cover this in a moment.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Welcome back to Winning in Retirement. I'm Brian Akers, certified financial planner practitioner, president and founder of Acres Financial Group. Here with me from Bress Route Law, Kevin Bress, an estate planning attorney I've worked with for many years. Kevin, you ready for the fourth quarter?
Yes, this is when I come from behind and win.
Okay. So you're an underdog.
Right.
That's okay. Now, this radio show is called Winning in Retirement. We have a website, AkersFinancialGroup.com. That's AKERS financialgroup.com. If you go there, you'll see our radio tab, and then right there is all of our history of radio shows. This show will be on that website very soon. If you go there, you can hear and rehear this. You can hear it through the website. You also can hear it through podcasts. Winning in Retirement Podcast, available pretty much anywhere that you can do podcasting. This show is called What is Your Legacy? What is your legacy? This is a very important piece of thinking that I think everyone needs to think about when it comes to their financial legacy. Now, life is about a lot of things. Now, I have a lot of things that I believe that are more important than even finance. But when it comes to financial legacy, we want to try to have a strong fourth quarter here, talking about family, kids, and legacy and what you need to know. And I thought we'd start with some of the tougher issues, and that is when you talk about your kids or family and you have people with special needs that need to be taken care of. What do you do for clients that come in and they have a situation where they truly need to care for someone now and even after they pass away? What kind of legal work do you do for people like that?
It starts with a trust, Brian, where let's just call it Sally. And
Sure.
Sally has some challenging issues. It could be medical disability, it could be a substance abuse issue.
Right.
And we don't want Sally to have money in her own name. So we can park money for Sally at death of the parent or ahead of time if needed in a trust. And the challenge for the parent is, who are they going to put in charge? Often it's a family member. Maryland actually has a group in Lutherville that will serve as trustee when there's nobody else to serve. So these are things to be talked about.
Right. Are these actual special needs trusts, or what's the wording that you guys use?
Yeah, the nickname Special Needs Trust, it takes it beyond what I just described
Sure.
and adds one more element to it, and that is to ensure that Sally can avail herself of government programs and not be disqualified because the government says, oh, Sally, you have $100,000 in a trust. You don't need us.
Right.
So we want the best of both worlds. We want Sally to be able to draw whatever benefits are available from the government, as well as use the $100,000 for things the government won't pay for.
All right. So really what you're doing was the basic talk of we have a concern about a kid or someone in the family, and we want to set some money aside. Trust is a good way to do that. And then if it's more stringent, where we have to also make sure they comply with and qualify for the government benefits they get, there's another type of trust for that.
Exactly. And the wording has to be very precise. So lawyers are often specialize in special needs trusts.
Are these trusts in wills, or do you design that trust right now? What happens with this?
That's a great point. Putting it in the will is sort of the obvious one, because when the parent dies, they want to make sure there's a trust. Setting the trust up now sometimes is done in families where there's grandparents who feel like, I want to help little Sally now and put some money away for her. So you form the trust currently, even while the parents are alive.
Right. Okay. So the idea today is this: what is your legacy? Now, your legacy is loving, caring, taking care of the people that matter in your life. So if you think about it, one way of doing that is to think of the people that are most dependent on you currently, and then you design your estate plan to provide that dependent care beyond you, beyond the grave, basically. Now, that doesn't have to be just one generation. It can continue beyond that through proper planning.
Right. There's so many folks who I run into want money set aside for the grandchildren. Usually it's a small amount, $10,000, $20,000. I apprise them of the 529 plans that I'm sure your office deals with. We don't, but we're giving them ideas, and then they go from there.
All right, so let's talk. We talk about legal and documents in certain situations. I want to talk a little bit about estate taxes, inheritance tax. You know, the fun stuff for us financial planners is taxes and things that we have to be concerned about. Could you explain basically when taxes occur upon death?
The death taxes are broken into three categories, Brian. Federal estate tax, 40%, but you have to have more than $13 million. Yet that law is going to change by 2026. If you listen to the debate last night, they brought it up. The tax laws are going to change.
Sunsetting in 2026, the tax cut in Jobs Act. That's for personal income tax and estate tax, and that's really the big deal.
Right. The Maryland tax will get you if you have more than $5 million. So the lucky people who have that problem, there's ways to leverage it to make it a $10 million exemption, but that's something to work through your planner with. And the final tax is the Maryland inheritance tax. It doesn't care how much money you have. It's about who you're leaving your money to. And if it's more distant relatives, it's a 10% flat tax on the money to a cousin, a niece, a nephew, a friend.
Right. And so this is money that you've done well in your career, and whatever you have left in your name would have this tax on it.
Or all three taxes for that matter.
Yeah. And so you said the number 40%, and then the Maryland tax 10%, and then there's inheritance tax. So that could be 50 to 60%.
One nice thing about Maryland is you don't double up on the estate and inheritance tax.
Oh, you don't? Okay, that's great.
You just pay the bigger one of the two.
Okay, they're okay, just the big one.
Right.
And then that's due how fast after someone passes away?
Well, the inheritance tax could be due on 30 days notice, and then they start charging interest and call you in default.
Wow.
But the estate tax is 9 months.
Now, estate tax is 9 months. It's due. Oh, wow.
From death, yeah.
From death. Now, a lot of times the estates take a lot longer than that, especially if they're not organized and not have documents together and everything else, right?
And it's just like the income tax program, Brian. The government says, oh, don't worry about that. File an extension, but please pay all the tax up front.
Yeah. Or there's interest on what you should have.
Or penalty, yes.
All right. So that's the basics of the estate taxes. Now, simple ways to exclude that is by doing something called estate freezing, or where you actually keep your estate where it is and try to take the growth out by giving some away. Now, because of the sunsetting of the estate tax law, there are some very big opportunities to give to make sure you don't pay tax in the future. People can give annually, but they can also give larger gifts through, I think it's called Unified Credit. What kind of gifting can people do?
Well, Brian, for our hopefully many ultra wealthy listeners,
right.
There's a strategy that the IRS has blessed, and it says if you give away a large amount of money today and Congress lowers the exemption in 2026, you get away with it. Okay. You don't get whipsawed like, oh, you gave away millions of dollars in 2023, but we lowered the exemption for when you die. We're going to now go back and tax that. They can't do that, and they shouldn't be able to do that.
And that exemption is $13 million per person.
Per husband and wife can give $26 million away, tax-free.
Now, let's say you do that. Do you pay a Maryland tax?
And Maryland has no gift tax at all.
All right. So what he's saying is this: if you do the planning before you pass away, you would avoid some future taxation from federal, depending on your net worth, but you can avoid what you give and have it set aside for the next generation and avoid that estate tax through proper gift planning. But then also, Maryland's not going to capture any of that 10% because you did it before death. So these are nice little things to think about when you're building your legacy on how to do this. As you are become very successful in life, a lot of times we're at a fast pace, like really hustling. We don't think about how fast net worth is accumulated. And all of a sudden, before we know it, the numbers are very large, and there might be a sudden death. And that sudden death leads to a lot of these large taxable estates. A lot of famous people, of course, Elvis is one of the ones, but they'll end up, they didn't even have a will. The idea is this: what is your legacy? Your legacy needs to be one of love, your family, love the people that you have lived your life and cared for. Love them by taking the time to sit down with financial planning and lawyers and a team of people to design this kind of planning for you, to make sure that you're taken care of at life's worst moments. What kind of advice would you give people just generally about how important it is to get this going? When
I came out of law school, Brian, the oldest generation I was dealing with had experienced the Great Depression.
Yeah.
If I had said to somebody who had $15 million, why don't you give $5 million to your kids? The answer I would have gotten is, but what if I need it?
Yeah.
And,
right.
As much as we do the math and try to show them budgetarily they're going to be fine, today we have baby boomers who understand these concepts and didn't live through a depression.
Sure.
And so my advice is be willing to be smart about taxes, and smart, unfortunately, means giving up some control of money. But it's either the government gets it or your kids get it.
If you maintain total control, you also maintain possible taxation. It's as simple as that. Through gifting and through a lot of other planning tools, things can be designed to make it work the way you want it to work. That's really the bottom line I want to get across. So what is your legacy? Kevin and I have been talking about this today. Your legacy when it comes to finance should be someone that's organized, someone that's been prepared. And the way we do that is having the legal documents in place that we need. Thank you very much, Kevin, for a good day. I appreciate your time.
Lots of fun, Brian. Thanks.
No, it is fun. I think it's fun to talk about topics like this. The main thing is making sure families are taken care of. I think that's a great legacy for our business reasons, right, Kevin?
I hope people replay this several times because it's a lot to sink in. We covered a lot.
And we didn't dig deep at all. There's a lot deeper we can go. We did not want to bore you too much. But we do thank you for listening to Winning in Retirement today. Our show's been called What is Your Legacy? You can go to our website at acresfinancialgroup.com. And on that site, you go to the radio tab, scroll right down. You can find this. It'll be labeled there, What is Your Legacy? And you can listen to the show again. Now, as you're listening to it, think about what is your legacy. Try to start writing down what you need to do and who you want to give to. Remember that Acres Financial Group, we're here to talk to you if you have any questions at all, because we want you to win in retirement. So take advantage of the opportunity to begin planning with us at Acres Financial Group. To schedule your free meeting with one of our team of advisors, go to our website at acresfinancialgroup.com. Scroll to the schedule a meeting section and let us know you'd like to schedule your free meeting. That's acresfinancialgroup.com. Or you can call us at 833-WIN-RETIRE. That's 833-WIN-RETIRE. We'll give you a call on Monday to schedule your free in-person or Zoom meeting with one of our team of advisors. Start planning for your retirement now. Go to acresfinancialgroup.com or call us at 833-946-7384. Thank you for listening. I'm Brian Akers from Acres Financial Group, and we want you to be winning in retirement.
You've been listening to Winning in Retirement with your host, Brian Akers of Acres Financial Group. Acres Financial Group offers securities through Archedios Capital, an SIPC and FINRA member firm. Advisory services are provided through Archedios Wealth. Acres Financial Group and Archedios do not share any common ownership. Neither Archedios nor Acres Financial Group provides tax or legal advice. Advice given on winning in retirement is general in nature, and one should seek further advice from their financial advisor, broker, attorney, and or tax accountant before investing. Be sure to read each prospectus carefully to understand all the risks associated with each investment. Examples and scenarios shared are meant to be for illustrative purposes only. Past performance is not indicative of future results.